Hello and welcome at this very short web lecture which is about the nature of contract law. We have two major approaches in contract law. That is the common law approach on the one hand and the civil law approach on the other hand. In common law we make a distinction between the consideration theory and the bargaining theory. The consideration theory is UK predominantly and the bargaining theory is USA oriented. In essence, the consideration theory means this. Something that represents legal value should be exchanged for something else that represents legal value. In short, the bargaining theory is slightly different. Instead of a focus on whether or not something represents legal value, we have a focus on did we bargain for this particular contract? So is there an exchange of favors in that contract? In the civil law theory, it is even different. In the civil law theory, we focus on our consent to be bound to a particular contract. So do we feel psychologically bound to this contract? Now, let's start with a very small example. I want to sell this wonderful car. And the street value of this car is approximately 3,000 euros. Now, there are two situations. Situation number one, I make a mistake in communicating to my business partner what kind of an amount I would like to receive for this car. So instead of 3,000, I write down 300 euros. And situation number two, it's my car and I don't want my heirs to get this car when I pass away. So I symbolically sell this car for €1 to Shanti, who is at this moment behind this camera. Now, when we apply the consideration theory in those two cases, in both cases there will be a contract because after all, both things represent legal value. 300 euros represents legal value, even €1 represents legal value on the one hand, and the car obviously also represents legal value. So it is an exchange of something that represents legal value and I fulfill the prerequisites of the consideration theory. Now let's take the bargaining theory. In one case, the 300 euros, there will probably be a contract because 300 euros, we've bargained for that and I want to sell my car for 300 euros. Unfortunately, I was mistaken about the amount of money, but still, we have bargained for this. We have communicated about this and it is actually an exchange of promises. However, the €1 might be a problem because this €1 is a symbolic amount of money which is not really bargained for. I actually just want to give away that car and I want to make sure that at some point it has been paid for, so there is some shape of a contract. But since it is a symbolic amount of money, we didn't really bargain for this. So based on the bargaining theory, this car is probably invalidly sold for €1. Now, if we apply the civil law theories, it comes down to the fact whether or not I feel psychologically bound to this contract. Do I consent to sell this car for a particular amount of money? The 300 euro obviously is an error and the other party could know this because the street value is 3,000 euros. So most likely there is no such contract for that. The symbolic thing of €1 is something else. Probably there is a contract as long as I really consent to it, as long as I psychologically really want this to happen. Now, going back to the common law theories, both the consideration theory and the bargaining theory, there's a slight undesirable side effect to these theories. Both theories presuppose that one promise should be exchanged for another promise, so that is a two-direction contract. This has the consequence that one-sided promises will never have any legal effect. This could lead to, again, undesirable situations. So for that reason, those theories are complemented with the so-called promissory estoppel theory. This means that if I, for instance, give away this car for free and I promise someone else that I want to give away this car just for nothing, that someone else might legally rely on this promise if that someone else could reasonably depend on this and in the meanwhile, for instance, took actions because he indeed believed that he would receive that car. So, for instance, he didn't buy another car in the meanwhile, or in his business activities, he also took into consideration that he would probably get that car. So, that promissory estoppel theory at some point complements the consideration theory and the bargaining theory to make sure that sometimes one-sided promises are also legally binding. Thank you very much for watching. For more information, check www.drwernert.com or like Dr. Wernert at Facebook, that is www.facebook.com/drwernert. Goodbye.